I call the honourable member Dennis O'Rourke.
Mr Speaker, at the first reading I thought that overall this was a good bill, but I said then that the devil would be in the detail, and in particular in the costs that it would impose for the out-of-court processes. I said that the bill would fail to attract cross-party support if those issues were not reviewed, and that New Zealand First would then have to reconsider its support. We in New Zealand First have carefully examined the detail of the bill, and we have listened to the very large number, over 200, of extremely well-argued submissions in various parts of the country. We initially supported the overall thrust of the bill. These were claimed to be as follows. Firstly, it would encourage faster and less expensive resolution for broken families who have issues concerning the custody and care of children to resolve, by requiring parties to participate in a new family dispute resolution process, instead of having to go to court for determination unless that was necessary, especially in cases of family violence. Also, lawyers were not to represent parties in FDR, but were able to give initial advice if on legal aid. The bill would focus the family court on matters genuinely needing a court decision, where protection of vulnerable people and children is prioritised. It would encourage parties to take responsibility for their own arrangements concerning the care of their children where possible. The bill would also seek to reduce the exacerbation of family disputes by making it not so easy to get to court, because legal proceedings often make relationships worse, but of course the court would still be there as a backstop. The bill would also seek to be more responsive to the victims of family violence, and we note that the bill expands the definition of psychological abuse, increases the maximum sentences for this from 2 to 3 years, and improves delivery of mandatory non-violence programs. The intention overall was to make the family court more efficient and cost-effective by refocusing its resources. It was always clear that the major objective was to save money, and also, of course, to speed up court applications by reducing the court's rapidly increasing workload. But New Zealand First support was always on the condition that, firstly, access to lawyers and to legal aid was preserved from the beginning of a dispute, including the FDR process. And secondly, access would be provided to publicly funded counselling prior to FDR, and that means preservation of the full system of counselling, not just 3 hours. And of course, that the costs of the proposed FDR process would need to be reasonable. Children's rights to separate representation would need to be preserved, and the effect of the bill would have to be to reduce and not increase power imbalances which would result from a party having financial means, whether privately or through legal aid, which the other party does not have.
I'm sorry to interrupt the honourable member. Honourable members, the time has come for me to leave the chair for the luncheon suspension. This sitting of the People's House is suspended until 2 p.m, when I shall resume the chair. Haere rā, kakati anō, good afternoon.